So, in this next set of slides, we look at the second issue that we considered in our seminar on theory in corporate governance, namely stakeholder theory. Recall that in the first lecture we looked at the debate between E. Merrick Dodd and Adolf Berle. Dodd asked the question, for whom are the corporate managers trustees? In other words, in whose interests must the company be run? We could modernize that now in the context of UK law by asking, to whom are directors' duties owed? We know in company law the answer is somewhat more complex than this, but in essence, that debate was characterized by a division between those like Dodd, who felt that the duties were owed to the community as a whole, and those like Berle, who felt that those duties were owed to the shareholders. Dodd's ideas really find modern expression in stakeholder theories of the company. In other words, those who believe that whatever the company is, it is surely more than simply the relationship between the shareholders and directors, as the economic theories that we looked at in the first set of slides tend to believe. There are, of course, some problems for stakeholder theory. Who exactly is included in that set of stakeholders? And even if we can identify without contention who those parties or interests are, how exactly are we going to include them in governance? What arrangements are we going to make? For example, are they going to have rights equivalent to those that shareholders have, or are we going to have some other arrangements whereby they are able to have their views taken into account? There are a very large number of different theories that fall within this broad area of stakeholder thinking about the company, but there's really a lack of clarity about the idea as a whole. It's often very easily criticized, indeed, by those who would favor the economic view, because there is that lack of agreement, and because sometimes there is a lack of clarity about what precisely the foundation is for claims being made by stakeholder theory. We could, of course, criticize the economists on the grounds that they too can't agree, but of course they are usually able to point to somewhat more firm foundations in terms of economic theorizing. This is where the paper that we looked at in the seminar by Donaldson and Preston is rather useful, because they have looked at the range of stakeholder theories available and have categorized them under three headings: descriptive, instrumental, and normative. So what we need to think about, of course, is what they mean by each of those terms. Recall that descriptive theories are those which, as the name suggests, are based on descriptions of existing examples of stakeholder organization. In other words, theorists falling under that category tend to point to existing examples of companies where, in one way or another, stakeholders other than simply shareholders are regarded as having more of a role in governance, and on the basis of that description they then set out a theory which is claimed to be more generalizable. Instrumental theories are based on a hypothetical, if-then conditional proposition, which suggests that if one adheres to the theory, then that will result in some desirable business outcome. So, for example, if one were to organize the governance of the company whereby stakeholders other than simply shareholders had governance rights, then that would, for example, result in higher levels of productivity or something like that. And finally, normative theories are based on moral or philosophical foundations, and in those cases the suggestion is that if one adheres to a stakeholder approach to the governance of the company, this is because it is simply right to do so in some respect. So, of course, there are a variety of different sorts of moral or philosophical claims that one could make in that regard, but it could be based on ideas of equality of respect, something like that. It is simply right that we acknowledge that stakeholders, whoever they are, have some right to equivalent treatment in the governance of the company. We are perhaps then making the claim that they should all have equivalent control rights in the governance of the company. So, this is helpful for sure, because if we're not clear what sort of theory we're dealing with, it's not easy to reach conclusions about what value that theory might have in terms of informing corporate governance reform. But notwithstanding the clarity that Donaldson and Preston undoubtedly bring to the world of stakeholder theory, they nevertheless go on to identify problems which each of these different types of stakeholder theory actually encounter. So in the case of descriptive theories, they point to the so-called naturalistic fallacy, that observation made by David Hume, the Scottish Enlightenment philosopher, that you cannot derive an ought from an is. Just because something is does not mean that it ought to be that way. So simply because one has identified examples that one characterizes as stakeholder governance does not mean that every firm ought to be organized in that way. In terms of instrumental theories, the suggestion that Donaldson and Preston make is that we simply lack empirical evidence that stakeholder theories do indeed produce the desired effects. And we could even go further and suggest that it would be quite difficult to design and implement experiments that would demonstrate unequivocally that better performance by a stakeholder governance company is attributable solely to that stakeholder arrangement. There are so many variables in play that it would be difficult to reach firm conclusions. It's possible to wonder whether the problems with descriptive and instrumental theories, which are rather obvious, one might suggest, indicate perhaps that in the end these theories are really at base informed by normative claims, indeed their authors' normative beliefs. And Donaldson and Preston essentially ask us to conduct a thought experiment in that regard. Were one to point out the problems with these theories to their proponents, would those proponents thereby change their view? In all probability not, because the suggestion is that really they're motivated by their fundamental belief that it is right that companies should be organized along stakeholder lines, and their reaching out for descriptive or instrumental justifications is really more of an attempt to provide some support for those fundamentally normative claims. And that, of course, is difficult because the authors, Donaldson and Preston, identify a fundamental problem also with normative stakeholder theories, because in the end, we can, of course, reasonably argue about what it is morally right to do in many circumstances. And certainly in relation to the question of how companies ought to be governed, reasonable people can come to very different conclusions. One may, for example, say that it is morally right, as we suggested earlier, to accord some sort of equivalence to the rights that different stakeholder groups should have in the company. Another person might make the moral claim that if we focus our attention on maximizing the interests of the shareholder, that will actually be the best way to ensure that all stakeholders in the company will benefit to the maximum extent. For example, the argument being that shareholder value is only maximised insofar as other stakeholders are as happy as they could be in all the circumstances. Now, that could lead us to the conclusion that things are not looking very optimistic for stakeholder theory, as much as they have brought clarity to the field by categorising different theories under these headings. They then appear at this point to have undermined all of those theories by pointing to the apparently unavoidable pitfalls that they each confront. Of course, that's not where Donaldson and Preston's analysis ends, because they go on to suggest that property rights might in fact provide a firmer foundation than anything that is heretofore found in the literature. And that, of course, takes us somewhat by surprise, I suspect, because we previously saw property rights being brought in to bolster a theory of the firm by an economist, Oliver Hart. And of course, we noted that others have been keen to use property rights as a justification for the priority of shareholders in corporate governance. But intriguingly, Donaldson and Preston perhaps have a slightly more sophisticated view of property rights. In the case of Hart, recall that he saw the owner of assets being able to withdraw those assets from those who are asked to work upon them, and in that way he explains how the owner, because of those property rights, is able to have control over the other inputs, notably human resources. Donaldson and Preston focus rather on the fact that property rights are not absolute. Indeed, when we talk about property, we're really talking about a bundle of rights and duties. So, property rights are not unlimited. We gave the example of the householder who, despite the fact that he or she owns the property, is not able to use it precisely how they wish, but really only to do so insofar as their use does not impinge upon the rights of others, whether those rights are related to delict or tort, to other forms of regulation such as planning law. So the limitations reveal the rights of other stakeholders as well as notions of distributive justice when we apply this idea of property rights to the company. We're no longer focused on simply the rights of the owner, but also the extent to which the rights of the owner are hedged around by the rights of other stakeholders. So the question then is whether, if we use property rights analysis in that way, we could indeed have a firmer foundation for a stakeholder theory, and one that may indeed avoid the pitfalls of descriptive, instrumental, and normative theories. It's a question, of course, whether that will work incontrovertibly in practice, but that's something that we'll bear in mind. So, in closing off this second set of slides, what we've done, in essence, is to get a clear view, I hope, of some of the economic theorizing and stakeholder theorizing about the governance of the company, a recognition that what these theorists are trying to do in one respect is to explain why it is that companies look the way they do and are governed in the way that they are, and in other cases to suggest that that acceptance of the status quo is not really appropriate, that we really need to be thinking in terms of what is more appropriate in terms of the rights of other stakeholders. Now, we've got a reasonable amount of information. We don't yet have perhaps the full picture. So what we're going to do in our next seminar is to look at the debate that surrounded the reform of UK company law about a decade and a half ago, or somewhat more indeed, and in that way, as it were, to see some of these theoretical issues being debated in a practical context. And hopefully that will move our understanding forward, and we can begin to consider where our sympathies lie in respect of these different theoretical views. So thank you very much for your attention.